Every day in the USA, people find themselves in court.
Versus Patricia Ann Turpin. It's case number 2023, CR 486. Amber Norris appearing for the state of Kansas. James Watts as defense counsel. Defendant Patricia Ann Turpin now appears at the court security Zoom location at the Judicial Center. Ms. Turpin, you were late to your
I
sentencing?
was in the other building. I didn't know which building to go to, and I ended up in the other building. That's why I was late.
All right. I don't think there's been court held in that building for 21 years.
I've never been to court here, ever. I
Well,
had
you're
no
here
idea.
now. This matter comes before the court at this time for sentencing. Docket notes from June 18th indicate that the defendant pled guilty to count 3, computer crime, a level 8 felony. A pre-sentence report was ordered, sentencing originally set for August the 12th, subsequently rescheduled to today's date. This court has received an updated pre-sentence report compiled by Ryan Smith, pre-sentence investigator, who is part of this meeting. I trust each attorney has received the updated report, and I'll ask the state's attorney first. Is there any objection to the criminal history as stated in the report?
I did receive the update, Your Honor, and no objection.
Any objection to criminal history by the defense here, Mr. Watts? Mr. Watts? You're muted.
Your Honor, no objection to the criminal history score.
Court will adopt the criminal history as stated in the report and finds that the criminal history score applicable to today's sentencing is criminal history score H, and the court will proceed further accordingly. Ms. Norris, do you know of any legal reason why sentence should not be pronounced in the Turpin case here this afternoon?
No, Your Honor.
Mr. Watts, are you aware of any such legal reason?
No, sir.
Ms. Turpin, are you aware of a legal reason or any other good reason why the court shouldn't proceed further with your sentencing?
No, sir.
We'll proceed further then. Counsel, I'm not aware that there's been a motion for a departure sentence or any other sentencing related motion to take up. Does the state have any such motions to pursue?
No, Your Honor.
Does the defense, Mr. Watts?
No, sir.
Very well. Are there any victims or members of a victim's family who desires to address the court in relation to this sentencing? Who is Deborah's iPhone? Or Jacqueline Green?
Your Honor, Jacqueline Green is the victim witness coordinator in the office.
Okay, all right, fair enough. And there's no family members with her?
Not that I'm aware of. And Your Honor, I'm not sure who Deborah's iPhone is.
All right. Is there someone whose screen name is Deborah's iPhone who wishes to address the court in relation to this Turpin sentencing? I would just like to have a yes or a no.
No, I do not need to address. This is Deborah, victim's daughter.
Okay. Did you wish to address the court?
No, thank you.
All right. Thank you. At this time, then, the court will ask for recommendations from counsel regarding an appropriate sentence for Ms. Turpin, beginning with Amber Norris on behalf of the state.
Your Honor, state would be recommending for the felony crime of computer crime. The court follow the presumption and assign defendant to 9 months in the Department of Corrections. Defendant would be able to earn 20% good time credit and would be subject to 12 months post-release. Defendant has earned 2 days of jail time credit. And Your Honor, this is a presumptive probation matter based on the crime and defendant's criminal history. So I asked the court to assign her to 18 months community corrections probation with all standard and PSI recommended probation conditions, including a drug evaluation, no contact, and Your Honor, This is a community corrections case, so the court will need to assess standard probation and costs of the case, but then also the community corrections fee. There is a $200 DNA database fee. There is restitution in the amount of $1,305.44. Some of that goes to the victim's family and some of it goes to the bank. We'll make sure that the dollar amounts are specifically set out in the journal entry. Mr. Watts is appointed, so the court will need to address court-appointed attorney's fees and the bid's application fee. And Your Honor, I don't think I have any further recommendations for the court at this time.
Very well, Ms. Norris. Mr. Watts, your recommendations regarding an appropriate sentence?
Thank you, Your Honor. Your Honor, we join the state's recommendation. They are in keeping with the plea agreement. I believe we join the recommendation of the mitigated 9 months with the post-release and probation durations and good time credits as noted. We likewise have no objection to the restitution that is set out in the PSI. I don't know that I have a whole lot else to add, Your Honor. Thank you.
Your fees and the representation of this client?
This is billed at $1,000 to bids. Or will
Thank
be.
you. At this time, the court will address the defendant, Patricia Turpin, personally and ask her if she has any statements that she wishes to make in mitigation of punishment or anything further that she would like to present to the court. Ms. Turpin?
I just want to apologize to the victim's daughter. I'm very sorry for what I did, and
Okay.
I really just want to say sorry to her.
Any other statements for the court, Ms. Turpin?
No.
Very well. Court will pronounce sentence in this case at this time. Court hereby establishes count 3 as the base sentence in the case for the offense of computer crime, a severity level 8, non-drug, non-person felony, in which the defendant has a criminal history score of H, thus placing her in grid box 8H. Court hereby sentences the defendant to a term of 9 months in the custody of the Secretary of Corrections, the state of Kansas. On this sentence, the defendant may earn up to 20% of good time credit and would be subject to 12 months of post-release supervision. No fine is imposed on that count. Court does note that in grid box 8H, this would be a presumptive probation case under Kansas law. There does not appear to be a special rule application here or a motion for departure to disturb that presumption. And the court will grant the defendant 18 months of initial probation term to be supervised by community corrections. Community corrections supervision is deemed appropriate due to the high risk score on the risk needs assessment that was conducted in this case. Conditions of that probation will be to report to an officer as directed, observe all laws, obtain a substance abuse evaluation within 45 days of today's date, and abide by the recommendations of that evaluation. She shall not possess or consume alcohol or illegal drugs while on probation. At her ISO's request and at her own expense, submit to random breath, blood, and urinalysis testing, perform any community service work pursuant to any program requirements, gain and maintain employment successfully throughout her probationary term, notify her ISO of any change in employment status, residence, telephone number, or email address within 48 hours of any such change happening, have no contact with the victim in this case or members of the victim's immediate family. She shall submit her DNA to the KBI data bank and be responsible for the $200 cost of the test, abide by any curfew or travel restrictions imposed by her officer, follow all standard conditions of probation, not have in her possession firearms or dangerous weapons, and avoid disreputable characters and places. The defendant shall also make monthly payments on her obligations owed to the court, which would include a felony docket fee, felony probation fee, community corrections fee, the $200 DNA fee, and a bid's application fee of $100. Attorney fees are waived, as the court will also be ordering this defendant to pay $1,305.44 in restitution to the victims in the case, as their interest may appear. Or again, will require $200 a month minimum, starting in a month to be determined by the court. Ms. Turpin, there's one other order that the court wishes to consider in this case. This court, unfortunately, has to see many cases where vulnerable people are exploited by others. I wish it was not so prevalent. However, this needs to stop. You are not new to the court system. You have, I believe, 3 prior property crime offenses on your record. So you're not new to this, and yet you exploited this helpless woman who was the victim in this case. And the court does have discretion, despite the fact that the legislature has determined you're not a prison case, that the court can impose up to 60 days in the county jail as a condition of probation. And that's exactly what the court's going to do here, Ms. Turpin.
Please don't.
The court is going to order you to serve 58 days more because you've got 2 days of jail time credit against that sentence.
Can we schedule it?
Starting immediately.
Oh,
Ms. Turpin,
please don't do
Ms.
this.
Turpin, you are an incredibly poor risk.
I've
going
never
to
done this
jail.
to
Hey,
anybody
don't talk over
before.
me. Don't talk over me. You're an
Please.
extremely poor risk to show up in jail on any type of schedule, because
I promise I will.
You could even make your sentencing on time today. Further,
I
last
was
time
in
you
the
were
other
directed
building.
to
I've never
appear
been there
at the
before.
Judicial Center and you didn't. Look, we're not going to talk over
I
each
went
other.
to the other building.
I've
on
made my
accident.
ruling. You're not going to cry your
Judge,
way out of this.
Calm down. Please.
All right.
I got my
Yeah.
grandkids outside.
All right. Are you done, Ms. Turpin, so that I can complete your sentencing? Again, the court has announced 2 days of jail time credit. At some point in the future, Ms. Turpin, you may have the right to seek expungement of this offense. Certain statutory limitations do apply. If you have any question about your right to someday seek expungement, you can address those questions to a lawyer and I'm sure get your questions answered. Under certain limited circumstances, defendants have a right to appeal their conviction to an appellate court having jurisdiction. And if defendants are unable to pay the cost of an appeal, they may ask the court to appoint a lawyer to represent them on appeal and that they be supplied with the transcript of trial court proceedings. Pursuant to KSA 22-3608C, you, the defendant, have 14 days after this judgment in court to file any notice of appeal with the clerk of the District Court of Butler County, Kansas. You do have the right to appeal this sentence if the court has ruled adversely to you, the defendant, at this hearing. I will remind you that there's prohibitions against a convicted felon possessing a firearm, and that there are losses of certain civil rights, such as the right to vote, until your sentence is fully discharged. Ms. Norris, I wanted to ask you, of all of the financial assessments you were asking the court to impose, has the court covered all of those?
Yes, Your Honor, I believe so.
All right. Mr. Watts, is there anything further from the defense side that the court still needs to address?
I don't believe so, Your Honor. Thank you.
All right. The court is going to order Patricia Turpin into the immediate custody of the Butler County Sheriff's
Please,
Representative
Judge, please, my
until her
grandkids.
custody can be transferred to the Butler County Jail to serve out 58 more days.
Please don't do
And Judge, what month did you want the payments to start?
Yes, we do need to come back to that. In light of the fact that she's going to be incarcerated essentially through September and October, of course, not realistically going to expect her to make payments during those months. So the court will start her payment obligation as earlier announced for the calendar month of November of 2024 and each subsequent month
Please don't.
until her obligations are paid in full. All right. I think the sentencing proceeding is concluded at this point. Mr. Smith, thank you for your work on the case and your appearance here today, Ms. Toronis. Ms. Toronis, she's a little bit emotional right now. Do you still want to have a session with her?
Yeah, I'd like to try if I could, please, Your Honor.
All right. So I'm going to go ahead and recess this proceeding. Ms. Turpin should stay. I'll just direct court security. She needs to make contact with her ISO so she knows what to do when she gets out of jail.
Please, Judge, please.
All right.
Let me schedule this jail time.
If there's
Please.
nothing further, the Turpin matter will be in recess at this time, and we can conclude the record and leave the Zoom meeting open for the ISO.
And Judge, I have Patricia Turpin here.
All right. Court next call, State of Kansas versus Patricia Ann Turpin. It's case number 2023 CR 486. Patricia Turpin appears at the court security Zoom location at the Judicial Center. Amber Norris appears as prosecuting attorney, and James Watts as defense counsel. Ms. Turpin was sentenced by this court on August the 30th of 2024 for a computer crime, a level 8 felony, with a controlling sentence of 9 months Department of Corrections, 12 months post-release, 18 months community corrections probation. As a condition of probation, she was ordered to serve 60 days in the county jail as a condition of probation. A warrant to show cause alleging probation violation was filed by Mr. Cutley on behalf of the Community Corrections Department, alleging that the defendant failed to report as directed. And apparently on January 8, she was directed to remain on the property of Sedgwick County Community Corrections until a urine sample was submitted. From that language, it's unclear what the violation was. I trust, Mr. Cutley, you're alleging she didn't stay on the premises or give the sample?
Yes, Your Honor.
Okay. Then the third allegation is that Ms. Turpin failed to attend substance abuse treatment as directed. What are your client's intentions regarding these allegations, Mr. Watts?
Your Honor, I discussed the matter with my client. It is my understanding my client would agree that she failed to report in February of 2025 and it failed to serve that 48-hour sanction. That she would waive hearing on that matter. She would likewise agree that she failed to remain on the property of Sedgwick County Corrections until a urine sample was submitted in January of this year. And likewise, she would acknowledge that she failed to attend a substance abuse treatment as directed. I would note that she is now entering that Miracles treatment program. In fact, I had sent an email to yourself and Ms. Norris with the documentation of that. She is now entering that Miracles program. In fact, when I spoke with Ms. Turpin, it was yesterday, she was speaking from that Miracles program. She really wanted to do this hearing from her treatment provider. However, I know Your Honor is very insistent about doing that from the courthouse, and that is where she's at.
All right, Ms. Turpin, your attorney has made an announcement on your behalf that you now intend to waive any formal due process hearing that you'd otherwise be entitled to, where the state would have the obligation of proving these allegations by preponderance of the evidence. You can challenge the state's evidence with the assistance of your lawyer, present your own evidence at a hearing, confront the state's witnesses unless good cause was shown, and among other lesser remedies, the court could consider just an outright revocation of your probation and having you serve the remaining balance of your sentence locked up. Do you understand these things?
Yes, Your Honor.
Is it your intention to waive a hearing in this case and stipulate and agree that you committed the violations as alleged in the warrant to show cause?
Yes, Your Honor.
Very well. Court finds that the defendant has knowingly waived her right to a hearing and stipulates and agrees that she committed the violations as alleged by Mr. Ketley in the warrant to show cause, failing to report, failing to give a urine sample as demanded, and failed to attend substance abuse treatment as directed. We'll now turn to disposition in this matter. Ms. Norris, what are your office's recommendations?
Your Honor, this is defendant's first warrant to show cause in this case. The court placed her on 18 months community corrections probation at the end of August of last year. So it would appear that she has almost 7 months of probation left. So I'll leave it to court's discretion on whether or not the court wants to do an extension or just have her continue on with community corrections with all previously ordered and standard conditions to include the drug alcohol treatment, and payment of fees, etc. And Your Honor, state would be requesting 2 days in the county jail as a sanction for the issues that she has had thus far on probation, and the court will need to address additional attorney's fees in the bids application fee.
Kelly, do you have any other remarks or recommendations to make to the court regarding this defendant and her probation?
No, other than she's the one that set up her own inpatient treatment, so it looks like she's trying to do what she's supposed to be doing, Your Honor.
As far as the prosecutor's comments regarding whether this case should be extended or not, do you have a view on that, Mr. Cutley?
I believe if it gets to the point when we get close to February, if she needs to extend, we can extend her at that time, I think. Hopefully she'll be done by then.
Mr. Watts, your recommendations regarding an appropriate disposition for Ms. Turpin.
Your Honor, we join the recommendation of the state as to the due date sanction to begin immediately. I'm with Mr. Ketley. I would think that the condition as whether or not it needs to be extended is something we can take up when we reach that time. If Ms. Turpin is diligent in getting her things done, that may not be necessary.
The court will address Patricia Turpin at this time, and I'll ask her if she has any statements that she wishes to make in mitigation of punishment or anything further that she would like to present to the court. Ms. Turpin?
Yes, Your Honor. Like they said, I am currently in inpatient treatment at Miracles, and I just got out of jail on the 1st of July, and I had served, I believe, from the 10 or 12 days of in you guys' jail, and I would ask that be counted as time served, so I may return to my inpatient treatment and continue on with my treatment.
All right. Anything else, Ms. Turpin?
That's it, Your Honor.
Ms. Turpin, I'm just going to make some observations here. Observation number one, it does appear that you need treatment. You apparently recognize that. You've entered into the Miracles program, but you've been on probation and out of jail since about November of last year. You didn't enter voluntarily treatment in November, December, January, February, March, April, May, or June. Only after you were facing revocation did you enter yourself into the Miracles program in early July. And I understand that you may have been incarcerated on this warrant for a short period of time, but you made bond. And then all of a sudden, apparently, you had an epiphany and you decided that after all this time and after all the urging done by your community corrections officer, you were finally going to take treatment seriously. Now, I don't know if your drug problem is so profound that you need a detoxification, which is usually a primary goal of inpatient treatment, but it also is somewhat confining. And perhaps that's the type of treatment program you need, because apparently outpatient doesn't work because you just don't go. So I'm wondering what's different now that this court would have any reason to believe that you're going to be successful on your probation. The second observation that I want to make, Ms. Turpin, is that you received a very harsh sentence at the beginning of this case. In fact, you got the most jail time that this court was legally authorized to impose as the start of your probation, 60 days. And you were quite emotional when the court sent you to jail. In fact, you did some, which I would just describe as wailing, to try to get this court to change its order, which the court did not do. And you served out your 60 days. And I would have thought that after that experience, Ms. Turpin, you would never take a chance of ever coming back before this court on a probation violation. But I'm disappointed that you're here. Because I thought that at that point you would take your property crime probation seriously. Whatever your officer asked you to do, you would do your best to do and not mess up in the way that's apparent before this court. You don't just get to decide that, well, I'm just not going to go to that treatment program. I'll find my own. I'll enter it. But there's one thing that's in your favor, Ms. Turpin. When I saw this letter from your attorney today, I thought that you are going to try to use this inpatient treatment program to get out of coming to court that you were ordered to do by Judge Crum. And the way Judge Crum knows that this court wants done, and that is you appear at the Judicial Center. You did show up, Ms. Turpin. That's a plus. Because the court would not have allowed you to use remote proceedings from the treatment facility. Mr. Watts is quite correct on that because he has considerable experience in this court. I want you at the courthouse, at the Judicial Center, at that location to face the music. And to your credit, Ms. Turpin, you did. Quite frankly, Ms. Turpin, this court's analysis, as everyone argued, was why should I order a short-term jail sanction when the long-term jail sanction didn't work? Do you have anything to say about that? 60 didn't work. Now I can order another 60. And maybe the second time you had a serious sanction, maybe it would make an impression on you that the first time didn't. But they're recommending a 2-day dip sanction. And quite frankly, is that going to make any impression on you whatsoever?
Yes, Your Honor.
Okay, why are things different now?
I just decided that the way I was living my life was inappropriate and not good for my health. And I'm very sorry for my actions. And obviously, I'm not getting no younger. And it's time to straighten up and do something different
Okay, different from what?
from the way my past, like you say, not handling what I need to take care of and not following the rules of my probation, and not just the rules of probation, just the way of that kind of lifestyle, the drug habitat, all that kind of lifestyle that's not appropriate.
Well, including stealing from others. Would you agree?
Exactly. And stealing from any kind of harm towards anybody in any kind of way,
Hmm.
including myself.
I'm also always disturbed when apparently there was some arrangement with your officer that you were going to do a 2-day dip sanction and you didn't show up for it. Explain that to me.
I was very scared that I wasn't gonna, again, I was high on drugs and I was very scared that I wasn't gonna get released after 48 hours, which is no excuse.
No, it isn't.
I made the mistake of not reporting like he asked me to, and that's my fault, and I'm very sorry. And there's really no logical explanation I can give you as to why I didn't show up. All I can do is show you that I can do better, that I am better, and that you won't have no more trouble out of me. And I can only, from this day forward, I can only show you that I'm not going to be back in your courtroom, that I have learned something from what you guys have from the very beginning to now, instead of making all these mistakes and keep coming back in front of you. I mean, like I said, again, I apologize for my mistakes, and all I can do is show you that I can do better, that I am better.
All right, Mr. Ketley, if I could address you.
Yes, Your Honor.
Mr. Ketley, obviously the record reflects that you attempted to do your own graduated sanction. In other words, a 2-day dip sanction, but she has not completed any type of dip sanction to this point.
That's correct.
All right. Ms. Turpin, when an officer tries to give you a break and gives you a 2-day dip sanction instead of taking further action, and then you blow that off, court considers that serious, or it's not inclined to just reinstate the 2 days. Court will impose a 3-day dip sanction as part of Kansas's graduated the sanction scheme. But Ms. Turpin, you're running out of chances. And this is a prospective sanction, Ms. Turpin. And I hope that the treatment program that you've entered, Miracles, which has had success with some other people that have come through my court, I hope you can have the same success with them. I hope they'll take you back after you serve the next 72 hours in the county jail. While you receive credit against your overall sentence for time previously served, the court will not give you credit for time against this prospective sanction. So you do have, I will order you into the county jail to serve 72 more consecutive hours, then be released back into the community on community corrections without extension. At this point, you're to satisfy any condition that has not yet been satisfied. Furthermore, this court will require, as a condition of your reinstatement, that you complete the program that you chose, Ms. Turpin. I'm going to presuppose Miracles will take you back, and that you are required by this court to successfully complete that program. Because you chose it, you recognize that that was the program for you. There's no reason that you shouldn't be successful in it. So that becomes an additional condition of probation for you to meet. And then if they make aftercare recommendations, you're going to need to complete those.
Yes,
So
Your
I'm
Honor.
sure they'll provide appropriate documentation to your community corrections officer as to what they recommend upon discharge, if you'll just sign the appropriate releases. Okay?
Yeah, and Larissa says.
All right. Ms. Turpin, again, I hope that this is the last time we have to go around on this. That you really do see that it's just better just to complete your requirements and get this behind you. The court will be waiving additional bids assessment in light of the court's incarceration order and her current placement in inpatient treatment. Finding additional bids amounts would be futile at this point. Anything previously imposed, obviously, remains to be paid. All right, Ms. Norris, is there anything else from your perspective that the court still needs to address?
No, Your Honor, thank you.
Any questions from you, Mr. Ketley?
No, Your Honor.
Mr. Watts, anything further from defense counsel perspective that the court needs to address here?
No, Your Honor.
All right, and finally, last but not least, Ms. Turpin, do you have any questions for the court regarding the court's orders made today?
No, Your Honor.
Okay. Well, I hope that they'll let you use a phone to call Miracles and let them know what happened, and that you intend to immediately report back to the program upon your release 3 days from now.
Thank
Okay.
you.
All right. The court remands her into the custody of the Butler County Sheriff's Office for her to be transferred to the jail to serve 72 hours in the county jail as a condition of reinstatement of her probation.
So what?
Right. If there's nothing further, then the Patricia Ann Turpin matter will currently be in recess.